in the great tradition of that seat. So let me. I think I'm somewhere in the middle of the conversation so far. I begin my federal courts course every year by reminding the students that there are three times in a democracy when you exercise choice. When you go into the voting booth and vote for whoever you want in secret. When you're a legislator and you have to choose to vote for or against some statute, or when you're a judge and you have to decide for or against in a particular case. And I said, if I believed that all three of those choices were equal, were equivalent, I would believe that American democracy is in a moral crisis. A judge doesn't do the same thing that a voter does, and shouldn't do the same thing that a legislator does, because these are ascending levels of constraint. When I go into the voting booth, if I want to be a bigot, and I want to cast a purely selfish or an utterly irresponsible vote, I can do so. It's secret. I don't have to tell anybody. I don't have to justify it. If I'm a legislator and I have to cast some sort of vote in public for or against a bill, that's significantly more constrained. I have to do it in public. I have to worry about re-election, and I have all of the constraints and assumptions of the society in which I live that I have to deal with. And then if I'm a judge, I think it's the most constrained choice of all. Because there is something to be said for judicial neutrality. There is something to be said for having a person who is somehow above the fray, functioning like an umpire, and functioning in a way that gives the litigants before the judge some confidence that the judge is at least approaching it with as open a mind as possible and trying to decide it on grounds that we would find consistent with the rule of law. And I want to suggest, as both Stanley and John did, that judging is extraordinarily complicated. It consists of both highly constrained principal activities and value formation, and that we've now, over the last 30 years of argument and debate about judging, I think come to what I can call the standard model of mainstream American judging. And we have a standard model, and it's the standard model that the Judiciary Committee should be looking for. It's a mixture of constraint and freedom. And it says to the judge, Judge, do you believe that your first duty is to seek out and see whether there are constraining rules that really tell you, from an external perspective, how to decide the case? Is there a governing precedent that absolutely governs? If so, are you prepared to abide by it? And that's a question somebody should ask Clarence Thomas. Because he believes that any governing precedent that wasn't decided in accordance with his methodology is not worthy of support. And so he has a vision of stare decisis, which is so far out of the American mainstream as to be extraordinary. But the first question is, are you prepared to be bound by precedent? Second, are you prepared to really take a good hard look at the text, recognizing, as Stanley says, that there's no such thing as intrinsic meaning in words, but also recognizing that when the text says that you shouldn't quarter soldiers, that doesn't mean the same thing as not quartering chickens. That the word quartering has a contextual meaning, and that you know what it means when you're talking about soldiers, and you know what it means when you're talking about chickens. And so are you prepared as a judge to really try to live with text and to apply it in a way that is consistent with both the people who write statutes and the people who write constitutions? And then third, if the text is ambiguous, are you prepared to try to figure out what the purpose of the statute or constitutional provision is, and do your best as a judge to choose the construction that advances that purpose? Now, I say that those are constraining factors. Recognize that that all three of those activities, deciding whether a precedent is binding, deciding how to read a text, and deciding what legislative purpose are intellectual exercises that are extraordinarily difficult, and that good people who disagree with each other will reasonably disagree about. So that it's not an automatic button-pushing thing, but it is an intellectual process which we expect our judges to go through. If a judge doesn't want to be bound by precedent, refuses to be bound by text, and doesn't really want to look for legislative purpose, then maybe that person shouldn't be a judge in this system. Now, it turns out that lots of cases, and there's a debate about how many cases, I actually think not as many as people think, but lots of cases, when you look at precedent and you look at text and you look at purpose, they don't give you seriously constraining judgments. You're left on your own after those three things are up. And then you have to choose the meaning based on consequences, based on what's the best meaning for this society. Judge Posner calls that pragmatism, somebody else calls it consequentialism, but what it really says is, after you've exhausted all of the efforts to be constrained, or trying to search out a constraint that makes you decide it one way or the other, you are then free as a judge to choose the consequence that is most important for the society. And that's where empathy, that's where experience becomes so important. No black man could have written what Wexler wrote about Charles Houston. Because Wexler didn't have that experience. He had the insular experience of a privileged white male living in American society in 1950, and he lacked the empathy to be able to imagine what it was like to live as a black man during that period. That's where empathy is hugely important, because when you make your consequentialist decision after you've tried to be a constrained judge and you've run out of controlling things, empathy at that point and the ability to put yourself in the shoes not just of who you are, but of other people in the society. I have no doubt, for example, that Sonia Sotomayor will be empathetic, but not just empathetic to Latinos. She will be empathetic to people who are before her because she knows what it's like to be on the outside. She knows what it's like to be an outsider. Now, somebody who's lived their whole life as an insider can still be empathetic. Bill Brennan was empathetic. And he lived, of course, as a Catholic and somewhat as an outsider in those years, but he was a fairly privileged. He lived a privileged existence, and yet he was able, one of the extraordinary things about him was how he could imagine what it was like to live in other people's shoes. She will understand what it's like to live in other people's shoes. And somebody like John Roberts, who is a brilliant technical judge, who will be able to tell you whether a precedent binds, who will be able to go through all the standard tropes about whether what text means, who will be brilliant in figuring out what purpose means. My doubt about him as a judge is I'm wondering whether he has the capacity to stand in somebody else's shoes when all three of those are exhausted and he has to make a consequentialist judgment based upon more than just his own experience. And so my hope is that we get both. We get good umpires who do whatever they can to be constrained judges, and we get empathetic consequentialists who judge things on the basis of us all when they have to go beyond that model.
I want to thank Burt, and I want to take up exactly where he left off, which is this question of empathy. And I want to ask the panel two questions. One is this a useful term? Empathy, when Obama said it the first time, I thought maybe it was a Freudian slip. But he said it a lot more times. And then he said it when Justice Souter stepped down. And my first reaction was, this is not a constitutional term. Empathy is something I try to teach my children. But I think he was responding to a failure in the conversation. Burt, you talked about this 30-year conversation about judging. And empathy, I think, was an effort to inject into that conversation something other than the tired old trope of originalism and strict construction on one side and living constitutionalism on the other. My question is this helpful? Does it lead to the assumption that empathy means you empathize with someone who looks like you or who shares your history? Because that's been the criticism. So I wonder if anyone wants to respond to the term itself. Is it a useful term? Is it moving the ball forward? Or is it in effect setting the trap that says judges are tribal and they side with the people who look like them?
Well, I guess I think that I don't normally use the term at all.